have any opinion on that foaming at the mouth pro-abortionists. Anyhow, but Senator Brown has voted with us. I'd like to thank you very, very much for your attention. We have a lot of people come in. In fact, I think the Bellingham bus might have come in. Yay, Bellingham! St. Brendan's! And so, without further ado, we need an update from the Heritage Foundation. The Heritage Foundation is a great place to go for information. You should Google it and go there for information on what's going on regarding constitutional issues, pro-life issues. And we have with us, to bring us an update on the health care issue, Robert Alt from the Heritage Foundation. Mr. Alt.
It's a pleasure to speak to you all today. I see that you brought your weather from the Northeast down with you. And it's great to participate in an event which, as best as I can tell from the media, never happens. So that's good as well. For folks in the legal community, the MCFL reputation precedes me. I come from a background where I do quite a bit on election law, and within sort of a class of cases, among lawyers, all you have to say is MCFL, and they know you're talking about the freedom of organizations to be able to speak and not have restrictions that they had attempted to place on organizations with regard to electioneering speech. So that's, it is an honor to speak before you today. And I'm very glad that Anne invited me. Anne Fox, her son, was a great ally of the Heritage Foundation when he worked for the Federalist Society before going to law school. So many of you recall around the time that the health care bill was passed, not too far from here on the Hill, then Speaker Pelosi was asked by a reporter, where specifically does the Constitution grant Congress the authority to enact an individual health insurance mandate? To which Pelosi responded, are you serious? Are you serious? Congressman Stark, subsequently from California, in a video that went viral on the internet, was asked by a constituent, if this legislation is constitutional, what limitations are there on the federal government's ability to tell us how to run our private lives? To which Stark responded, well, I think there are very few constitutional limits that would prevent the federal government from rules that could affect your private life. Now, the basis for that would be, how does it affect other people? When asked for clarification, based upon silly concepts like enumerated powers and other restrictions in the Constitution, Stark clarified, all right, the federal government, yes, can do almost anything in this country. We recently had Attorney General Cuccinelli from Virginia come and speak at the Heritage Foundation about his litigation challenging Obamacare, and he related this story, which I think is somewhat interesting. Back prior to the Declaration of Independence, you'll recall that King George passed a number of taxes and tariffs, and in response to that, the colonists enacted a boycott of certain British goods. This did not sit very well with the king, who first brought in his Solicitor General, his chief attorney, and said, they're boycotting our goods. These guys are our colonists. Isn't there a way we can force them to buy our goods? The solicitor said, well, no, there's no lawful way to do that. Unhappy with this answer, King George then went and consulted the House of Lords and explained his dilemma. This cash cow was drying up because this boycott wasn't there a way that we could make sure that we got these taxes by forcing the colonists to purchase the goods? No, can't do that. And so nothing ever came of it. It's a bit disturbing when our government today is claiming an authority that even King George recognized he couldn't impose upon us, which is the ability to force you to purchase a good on the market from a third party, and if you choose not to tax you the equivalent value. And that's really what's at stake. Now, of course, everyone in this room knows, there's also a whole host of other problems with the bill, including erosions to the Hyde Amendment, which was papered over with an executive order, which of course could be nullified at any moment. So there's all kinds of fun things in the legislature. And so it's being fought on a couple of fronts, as you know. One, obviously the House passed a repeal measure last week, which Reid has promised to, apropos today, throttle before it's born in the Senate. But there's litigation going on in multiple fronts. First of all, of course, in Virginia, we've had one district court judge find that the bill is unconstitutional, that it exceeds Congress's authority under the Commerce Clause to force you to buy insurance. The second piece of litigation, a major litigation, is going on down in Florida. At this point now, 26 states, more than half, have joined that litigation. And I am very pleased to report that the rumor is we will be hearing a decision yet this week, perhaps even today, but this week in that case, and all indications are that a second judge will be striking down at this legislation. We should not let up. It is far too common a mistake, as you all know well from your movement, to simply rely on the courts to fix ills. Many have been led astray by that strategy, and so we need to push forward on all angles, including legislative approaches. And so I understand that you all have petitions that you'll be taking to your members today. I work for a 501c3, so of course I have no particular position on any particular piece of legislation. However, as a general strategy for reform, I would say that a legislative response and a judicial response is the proper way to seek change on this or any other issue. So I'll be happy to. I forgot. Anne had actually asked me to address one question, which a lot of folks which is severability, which is this sort of funny legal term with regard to what happens when a court strikes down part of the bill. Sometimes in statutes they put severability clauses. What'll say something like, well, if you strike down one part, all the rest of it is left standing as if nothing ever happened. With the Obamacare legislation, you remember we had kind of the race to get it done. We had to pass it so we could find out what it said. The House version of the bill, which ultimately did not get enacted, had a severability clause in it. The Senate version, which got rammed through because some senator from the Northeast had gotten in, and I don't know, they were a little concerned about this. It did not have a severability clause, and that's the version that finally went through. Now, courts, the one problem is courts will generally read in a severability clause. There's a presumption in favor of judges, like not to have to strike down an entire bill. They like to sort of take out their blue pencil tool and strike out bits and pieces and leave the rest standing. But there's a couple of exceptions, and the law is actually pretty clear. If ever there was a law which that presumption didn't apply, I would say it's this one. Because there are clear statements from some of the key proponents on the floor that, look, without the mandate, this thing, we don't support it, it wouldn't fly. You've got even the Obama Justice Department filed papers in court and said that the entire healthcare system in the United States would inexorably fail if the mandate were struck down, and the must-carry provisions. Remember that the bill also requires insurance companies to carry individuals with pre-existing conditions. If the must-carry provisions existed and the mandate didn't, it would lead to system-wide failure. So it's pretty clear that the standards that the court looks to is whether or not there's other parts that are reliant upon the part that's struck down, or whether or not the legislature would have enacted the bill if the offending provision were gone. seems pretty clear that that in this case the statute should be struck out as a whole. My prediction to you is it will not. I think the decision, your likely decision in Florida, for instance, will be I think in many ways a more robust decision based upon the comments that the judge made at arguments last month than even the one you saw in Virginia. But he seemed hesitant as well to strike down the whole statute. I think he'll strike down a good chunk of it, but not the whole thing. And so, of course, that's important to folks in this room who are concerned about some of the funding provisions that might affect issues related to life as well. So that's something for you all to keep an eye on and to be thinking about as these decisions come down. So with that, I'll be around for a bit if any of you have questions. I'm happy to chat. But thank you once again for having me today.